I want to call this scheduled meeting of the Public Safety and Homeland Security Committee to order. I'm going to ask Gerald Green if he would provide us with an invocation.
Let us pray. Our dear Heavenly Father, as we gather together to do thy business and the state's business, we pray, oh Father, that thy blessings will be upon us. Watch over and protect the leadership of this state. Watch over and protect each and every member of this committee. And Lord, we just thank you for the opportunity to come and to serve in this great state. Father, be with us now, guide us and direct us, and bless each and every one of us as we ask all of this in the name of our Lord and Savior, the Lord Jesus Christ. Amen.
Thank you. Ladies and gentlemen, before we start our meeting today, I want to turn your attention to the screen here. 5 years ago on this day, Deputy Commander Patrick Carruthers with the U.S. Marshal Service lost his life while executing a warrant to apprehend a fugitive down in Allenhurst, Georgia. I did not personally know Marshal Carruthers, but I have a good friend who worked with him for several years, and I just want to take just a moment to ask those to just remember this family and honor his service for the life that he gave serving and protecting our state and our country. Our meeting was supposed to be scheduled around the Fulton DA, Fonnie Willis, and she called late last evening and had to reschedule. She had some commitments that she just had to meet today. She was very apologetic to myself and to the committee, and we're hoping to try to get her rescheduled for maybe Monday afternoon before everybody goes home. So hopefully we'll be able to have another public safety hearing to discuss some of the issues that are facing Fulton County. We have with us today some members of the Bail Bondsmen's Association that are going to come up and speak. If y'all would like to do that at this time, are they here? Yes. Okay. If you'd like to go ahead and come forward, and we'll kind of let them follow up, but behind you, if you don't mind. If you want to sit at the desk, or if you want to go to the podium, okay. Yes. Do we? Let's get that for you then.
Yeah, you can. I can share my screen and you can tell me when to change it, I reckon.
Mr. Chairman, I believe he did say that.
What's your email? Abby, ABBY.
Media Services.
.day at house.ga.gov. Okay.
House Media Services has that. We're working on getting that pulled up for you right now. This meeting's probably not going to be as exciting as the one going on below us today, but we're gonna work through our meeting, so you can go down and attend that if you'd like to. All right.
My name is Jeff Hamlin. I'm with Cornerstone Government Affairs. We represent the Georgia Association of Professional Bondsmen. And I got really some data I want to give to you today. Tell you a little bit about the collection of this data for the last few years. I presented to the Senate Public Safety Committee probably about 3 weeks ago this same information, and I just want to give credit to the magistrates who reached out to Chairman Albers as a result of that and asked for the list of judges that we had so that they can self-police themselves. So I want to give them credit. They realized that maybe some of their members were not following the script of the law and asked for that information and asked to hopefully self-police. So you want to go next slide there? Sorry, this will be fun. I don't, Mr. Chairman, I wanted you to be able to look up there at the screen. I wanted to capture your attention, Mr. Chairman. So many of you, I know that this has been a discussion in some of your previous committee meetings talking about signature bonds. I know Chairman Powell and Chairman Jaspers and others have brought this up. So I want to tell you a little bit about signature bonds and kind of the legislation that has gone through the legislature the last couple of years. All right, so signature bonds are a type of bond that allows judges and prosecutors to release offenders by signing court documents promising a return for the court. One things that we have seen in some jurisdictions, Fulton County, DeKalb County, Clayton County, some in Augusta, and really Athens Clark, is the assignment of a dollar amount to a signature bond. The difference between that signature bond with a dollar amount and a regular, or sometimes called a good bond, is the good bond has a collateral or surety backing that up. So if you fail to appear to court, that collateral is then, that bond is then forfeited. With a signature bond, that dollar amount is not forfeited. There's nothing you're putting up, no property or anything else. So we started collecting some data. If you want to go to the next slide there. There you go. So this is a summary of about a 4-year period from January 1st, 2017 to October 16th of 2021. This shows you the total number of defendants, and this is all Fulton County. Sorry about that. Total number of defendants released via unsecured bonds, you're looking at about 30,000. Total number of offenses released via unsecured bond is around 60,000. And then that dollar amount that I was telling you attached to a signature bond, that adds up to about $230 million. So here are some of the charges that did receive one of those unsecured bonds. You see the breakdown there. 4,900 family violence offenses, 114 rape, 7,800 theft, 3,300 failure to appears, 11,000 drug possession, 678 entering an auto, 564 possession of a firearm by a convicted felon. If you want to go to the next slide there. So to get that information, that required an individual search through every arrest in Fulton County in that 4.5-year period. You can imagine the amount of data that we had to pull to do that. And all this data is in those 2 books right over there. If anybody wants to go look through them. I know the bondsmen obviously have an interest in bonds being issued. So I want to make sure that if anybody questions the data and who was collecting it, all of it is in those books to verify. So this slide here has all the charges broken down by year, number of unsecured bonds given, and I'll get to that 2021 number a little bit later. We'll talk about why that's highlighted or kind of bolded in black. But you see all the offenses that are in orange are ineligible to receive a signature bond as of the beginning of this year, 2021. That was some legislation that was passed last year that I'll talk to you about. I know that's really small font, but you can hopefully make out some of those charges on there.
And
Go to
this
the
was-
next couple slides. Yeah.
This was also emailed to your house account too, folks. So if you want to pull that up, you have it on your house account.
All right. Abby, if you want to go to the slide, recidivism. The next one. Oh, okay. So point is, a lot of people, there's a lot of studies out there that show that people say that cash bail is not directly tied to someone's ability to appear before court, to come back and appear before those charges. So that was, I wouldn't be sitting here if we felt like that wasn't the case. So as part of the data collection, we then had to go into the Fulton County Court Systems website and cross-reference every one of these individuals that was released on an unsecured bond within the Fulton County Court System to see, did they show back up for court? You'll see 2017, 2018, roughly 1 out of 3. The reason the numbers on 2019, 2020, 2021 are low, a lot of those cases have not yet been adjudicated. I would suspect that those numbers will probably rise up to be about 1 out of 3 as well. And then also we have the pandemic that the court system's been dealing with. You know, we saw one the other day, and I understand that there's a lot more context to every arrest, and judges seeing things that we are not able to see, the general public, or through a website. But we saw one the other day where someone was arrested on a felony charge, given a signature bond. They failed to appear. A bench warrant was issued for them to, and then they were rearrested and given another signature bond. To me, that just doesn't make sense. If you don't show up for court, you're given another signature bond after that. You want to go to the next slide there? So another thing we really tried to look at, and this is the amount of information that has to be collected to really go through this amount of data is unbelievable. But this, we took one sample size. So we took January 2017. And the defendants that were released through some means of unsecured bond, whether that be a signature bond or pretrial release, and subsequently were arrested again on new charges, unrelated charges. Of the 617 defendants released by unsecured means, 235 were rearrested for new unrelated charges. That's about 38% of all the defendants who had been released in January 2017. 4 were charged with a new crime the day after being released. 12 were charged with a new crime within 10 days, 45 within a month, 84 within 3 months, 122 within 6 months, and 162 of those 235 individuals was within 12 months. So within 1 year, they were rearrested on a separate unrelated charge. Go to the next slide. You can go to the next one. Sorry. There we go. So when I told you about 2021 and why that number was highlighted there earlier. So in 2020, there was a Senate Bill 402, and this dealt with kind of really going through the signature bond process and redefining that. So that was, the signature bond was redefined as an unsecured judicial release. So you could not put a signature bond, you could not put a dollar amount on a bond if it wasn't backed with any kind of collateral or surety. So it was redefined as an unsecured judicial release. They prohibited an assignment of the dollar amount on a signature bond. You couldn't call it a $40,000 signature bond if there was nothing backed up behind it. Go to the next slide there. Then also in that legislation, put a number of offenses that prohibited a judge from releasing an offender on an unsecured judicial release on some serious violent charges. You'll see them up there. It's murder, armed robbery, kidnapping, rape, aggravated sodomy, sexual battery. Next slide. in addition to ag assault, hijacking a motor vehicle, aggravated stalking, child molestation. Basically, your worst of the worst, your violent, sometimes sexual crimes. Those are no longer eligible to receive an unsecured judicial release. And that's a result of Senate Bill 402 that passed in 2020. That bill went into effect earlier this year, January 1, 2021. And I will give a lot of the judges credit. They have been adhering to the law since then. There are still some examples where people are released on unsecured on some of those charges that are listed right there. I'll get into that in a little bit, but we'll go to the next slide. And then lastly, just define who is and isn't eligible for an unsecured judicial release as a elected judge or judge sitting by designation. And that term is actually usually a magistrate or sometimes state court judge sits by designation for a superior court judge. And that's why that's in there. Next slide. So I mentioned how there were still some examples of judges releasing people on some of those charges that I mentioned. You'll see up there in 2021. So that bill went into effect in January of this year. You have, sorry, my video up there is blocking it, but it says bail restricted offenses there on the right side. You have 32 were given by a elected judge, and then an unelected, appointed, or unknown. Sometimes you can't figure out who it is that actually released that individual. You have about 440.
So is it my understanding that they're appointing these folks to sit on the bench, and they're the ones who are doing all these releasing with unsecured bonds?
Yeah,
is that right?
It's well. And I know we have some members of the judiciary here who can explain it better than I can, but most of the time a bond hearing is done by a magistrate judge.
Right.
In Fulton County, there's a chief magistrate judge, and that individual is elected. And then they appoint magistrate judges under them, and those people are not elected. Some charges actually are required to see a superior court judge.
Yeah.
I think that's kind of your 7 deadlies, murder, rape, all those. But the vast majority of the charges that are coming into the Fulton County court system are seeing a magistrate judge in Fulton County. Go to the next slide. So this was actually a report that we found by the city of Atlanta. Some of you probably know that in 2017, the city of Atlanta eliminated cash bail for municipal violations. So that's municipal court violations. And that could be jaywalking, just a lot of the somewhat minor crimes. They eliminated cash bail to be given out to those individuals. So there was a study done to kind of see, all right, we've gone to this cash bail system. Are people showing back up to court? If you want to go to the next couple of slides. Go to. So this is done by the actual municipal court of Atlanta earlier this year. This is their data that they presented. Next slide. So this shows the signature bonds given by year in the city of Atlanta on these municipal violations. You see the numbers. It's 11,000, 7,000. Next slide. About probably 80% of those were signature bonds, with the rest of them either being some kind of surety or cash bond. Next slide. So the point is, here's your failure to appear rates since that policy went into effect in 2017. So essentially, it's about 120% increase in failure to appear. So that's, again, going back to the slide I had earlier about 1 out of 3 that are getting unsecured bail are not showing back up for court. Next slide. And then this is another slide that they had in the report showing about 1 out of 3 were reoffending on some kind of a different municipal violation. Next slide. This is actually coming out of Harris County, Houston area. They, as a result of, I think, of a court decision, went to no cash bail for misdemeanors only in the Harris County court system. The DA ran on no cash bail. She fully supported it. But as they had an independent monitor that was supposed to see if people were coming back, showing up for court. That monitor continued to say that, yes, the failure to appears remain the same. People are not being rearrested. Well, the DA and her staff did not believe that because they were seeing the same individuals coming in and out. So they ran their own analysis. And so next slide, you'll see their report. This is terrible. I can't barely read it too. But basically, this chart sets out the number of defendants who are on a bond and then charged with a new crime. So defendants on misdemeanor bond at the time of the filing of a new criminal case, and you see the numbers when that went into effect in 2015. There were 3,200 reoffenders. In 2020, that was 10,000. Even before the COVID pandemic, it was 7,000. Defendants on felony bond at the time of the filing of a new criminal case, around 3,000, jumped up to 11,000, and then you see the total there. Next slide there. And this is a graph just showing that same thing. Go to the next slide. And the next one, same graph.
That's crazy.
This is looking at the failures to appear of those individuals. The chart demonstrates that in 2018, bond failures to appear on general order PR bonds, those are signature bonds, had a 438% increase from 2017, and a 606% increase from 2017 was in 2019. Next slide. So as a part of this, the Texas legislature actually just a few months ago passed bail reform legislation. And I think it's something that you will hear from the judiciary and the DAs and really every member of the public safety system is that the data and the information is lacking in the courtroom. You'll have an individual come before a judge on some kind of bail determination, and the clerk doesn't have their full criminal history. The DA doesn't have their full criminal history. A lot of that is some of the clerks haven't entered the information into the system yet. So Texas was seeing a lot of the same problems. So what they've done is create a new database so that information has to be entered timely. So it's somebody got arrested in X county. They got a $4,500 good bond, or they got a signature bond. And that is all in one database that is compiled and seen by every member of the judiciary, both the DA and the judges, so that they can make an accurate decision if somebody gets rearrested 2 weeks later on another charge. That's something that I believe there's some interest from the governor's office and others at looking at something like that here in Georgia. And I, again, have to defer to the judges who can probably tell us a little bit more about that. Next slide. This is, I don't know, will that play, Abby? If not, we can skip it. Basically, this individual, about 3 years ago, maybe 2 years ago, got out of a car on 2 consecutive days with an AK-47 and shot up an entire apartment complex. So he did it on a Monday morning and then came back on Tuesday morning and did the same thing, just sprayed erratically.
Where was this?
That was in Atlanta.
You have specific.
Yeah. You go to the next slide, you'll see his bond order. So there's all his charges: aggravated assault with a deadly weapon, got 10 of them. Commission of a firearm or possession of a firearm during commission of felony, blah, 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 criminal damage. So he got $120,000 pretrial release. And if you keep going down 2 more slides, you can see, or next slide, you see that $120,000 amount. There you go. And then the next one, you'll see he's not to possess a firearm. Well, about 5 months later, there was a shooting down at the Clark, Atlanta. There was kind of a block party at the beginning of school. That guy is the one who got into a firefight with somebody else right there on campus. He is now sitting, I think, hopefully still in jail. Next slide is just another example out of Athens. Again, I mentioned Athens is also kind of a problem area. You'll see an individual who's arrested he was suspected of rape of a recent UGA grad. I think a girl was walking through North Campus in downtown Athens, and he is suspected of raping her. He was on a signature bond in Athens currently on another charge. You'll see that on the next couple slides. Oh, two more. There you go. That's his bond order on a signature bond on other charges. Last two slides, I promise. I'm coming to an end here. This is just one example of, we keep talking about repeat arrests, recidivism, repeat offenders. This gentleman, I can't remember the number. Next slide. He's had about 18 arrests, maybe 20 arrests in Fulton County since 2001. And the part to me that just doesn't make sense. So this is a known drug trafficker, multiple felony arrests. Earlier this year, in April of this year, he was arrested for possession of firearm by a convicted felon. He got a surety bond, so a good bond. 4 months later, he was arrested for the same thing and got an unsecured judicial release. And that's one of those offenses that is now on the list that you're not eligible to receive an unsecured judicial release. So you're talking about a convicted felon who is then busted twice in a 4-month period with a firearm, going right back out on the streets.
Who's his lobbyist?
Not me. That's Abby, it's the next two slides. You'll see that information. That's his arrest record. And again, this is all just Fulton. There's not saying that there's not more in DeKalb or Clayton or anywhere else around the state. Cobb, that's just Fulton. That's it, Mr. Chairman. Happy to take any questions.
For members of the committee? Any comments from the members of the committee?
Figured this was coming.
Chairman Powell.
Couldn't hardly see this, that you didn't bring a paper copy. It's a little small for my.
I will next time, Mr. Chairman.
But it appears that it's getting better, that a lot of the judiciary is getting better.
Yeah.
But there's still some questions out there about some of the personal recognizance bonds.
Yeah, and I will say, Chairman Powell, that I know that members of the judiciary, like I said, reached out after that last hearing and said they want to self-police. I've heard just through the grapevine that there has been some training that has gone on with members of the magistrate court there in Fulton County to make sure that everybody is aware of the laws that y'all have passed down here to make sure that they're adhering to those laws. So I think we're going to see some improvement and continue to see that in the future.
But you're also saying that most of this would be in the more inferior courts.
Yes, in terms of being a magistrate level, yes.
Number 26 down there. Who is that? Chairman Taylor.
Thank you, Mr. Chairman. I'm sorry I was late here, but I was Zooming in another meeting, and it's almost startling if we hadn't seen this going on in the news. And I feel like there's something this body needs to address, whether this is going to help with the judiciary having more training. I think they have a lot of training, and I'm having a hard time understanding why they're having trouble stopping letting these criminals out. That's just something to have repeat offenders with serious felonies out again on no bond or on very low bond. And if this body needs to do something, I think they need to step up and do something, because this cannot be tolerated in a civil society. And I think anybody in this room wants to be able to walk the streets safely. And there are times when it's not possible anymore. So I think it's something we need to look at. Thank you.
Okay. Number 18.
Yes, thank you, Chairman. And I would be very interested in this database that you referred to that Texas did, where if maybe having the shared database to know all the potential charges that these victims have had and all their arrests and everything. So you said the governor's office was looking into that, or and
I
so
believe so.
there may, so that would that be legislation that would pass, or is that something they could do without legislation?
I am not sure on that. We have 159 counties and they all have their own software. So those don't always communicate with each other. So they have to rely on GCIC to look up somebody's arrest record. So when I say that a clerk might be delayed in entering some of those cases that have been adjudicated into the system, that is probably where you're not able to see that if somebody was released in DeKalb, 10 days later, they get arrested in Fulton, you can probably see that they're arrested, but you don't see, are they on a real bond? Are they, are they on an unsecured bond? That's probably the biggest challenge we have is in terms of those systems communicating. And we got an overcrowded jail, Fulton County. Probably don't have enough judges. You probably have an underfunded DA's office. Those are a lot of the different factors for some of the things we're seeing, and ultimately have an impact on crime here in Atlanta.
Any other comments or questions at this time? Colonel.
Well, I've worked all over the state in just about every one of the 159 counties, and it runs the gamut. And in particularly some of the smaller counties, they're very stringent about bonding. The metro areas are much different. And I assume, as I've watched, that it's because of the volume. I mean, judges here see things on a daily basis that some judges in rural areas never see in their entire career. And I feel good about what's transpiring right now with the increase in requiring bonds. Back in next month will be 11 years ago, I had a young state trooper that was shot and killed by somebody who was out on his own recognizance after, and he had a criminal record much like one that you displayed here. And I was just astounded that that could occur because I had worked in many rural areas where that would never occur. I mean, but I think they're taking some positive steps, and I think requiring bonds in certain offenses certainly is, and you can't take judges' discretion totally away from them. I mean, every case is different, and they have to have the ability. They're there because they're supposedly wise people and have the ability to discern what ought to occur as best as anybody in our society can. But sometimes I think, and it's like anything else, when you see a law enforcement officer get in trouble or a politician or somebody, it makes the headlines. And when somebody's out on their own recognizance and they do something, it makes the headlines. And I think they get more publicity sometimes than they deserve. But it shouldn't go on. When you have a repeat offender who's violent, and I've been in other locales where the federal judge has interceded and the jail's full and the sheriff's getting fined $2,000 a day for every inmate that he has in there that is over the limit. So, I mean, it's a
challenge.
It's a challenge that I don't see any good answer for. I mean, everybody tries. We certainly want to try up here, and we want to make our communities as safe as they can be, and put the people, the 5 or 10%, probably about 5% of the people whose culture is that they become involved in these violent affairs. And, they continue and they continue and they continue. It's the same ones time after time after time. 95% of our population are law-abiding citizens that don't ever cause anybody any problems. It may be a speeding ticket here or there, but those people need to be put away and stop from preying on our fellow citizens. So
we actually had Colonel, thank you. We actually had an example as part of that 1 month snapshot that we were looking at. We were talking about recidivism. We found an individual who in January 2017 was arrested on 4 misdemeanor charges, received a signature bond, and I think 3 months later committed a murder. Still, that murder is still pending. He got a $185,000 good bond, so an actual bond, and I think got out of jail. He's been arrested 3 times since then, with getting signature bonds on, I think, 2 felony charges since that time.
That's unfortunate. That has to stop.
1 felony charge, not 2. Sorry.
That has to stop. Any other comments or questions? We certainly appreciate
Thank you,
you
Mr. Chairman.
and disseminating through this information and getting it to us. It's very valuable to this committee. Okay, we have Judge Brasher that wants to come and give some testimony to the committee.
Yes, sir.
Thank you for being with us today.
Somebody left the phone. Good afternoon, Mr. Chairman, members of the.
Yeah, just pull that microphone over there to you.
Thank you. Appreciate it. Good afternoon, Mr. Chairman, members of the committee. It's a pleasure to be here with you. My name is Chris Brasher, and I'm the Chief Judge of the Superior Court of Fulton County. I've been Chief Judge since about 5 weeks before the pandemic hit last year, and so great timing. But we are, good news, we are open. The courts are running. We're back almost to pre-COVID capacity. We've tried probably 75 or 80 jury trials in Fulton County since April of this year. And we also have in place a program funded by the American Rescue Plan Act funds that Fulton County got, not from the state, but Fulton County got, that will increase our court capacity by about 25% for the next 3 years. It'll allow us to work through the backlog of cases. I know you'll hear more about that from District Attorney Willis when she comes to talk to you. My focus is really about violent crime, felony violent crime. That's what I want to talk to you about here. Let me start from the perspective of what my background is. I've started out as an assistant DA. I worked at the Attorney General's office for 11 years in the post-conviction and in the criminal justice division. Represented Colonel Hitchens when he was Colonel of the State Patrol and also Director of Homeland Security. And I was appointed to the bench 16 years ago, served on the bench since then. I've tried over 100 murder trials, including 2 death penalty trials, handled about 15,000 cases as a judge. The number one reason why I became a judge is because I've raised a family in Fulton County. It's important to me to have a safe community. And so what I've passed out to you all is not an attempt to dissuade or discredit or go back on anything that was said. I'm not here to try and take up for poor decisions that might have been made in cases. What I am here to talk to you about is the pretrial release system that we have in Fulton County. And when you hear about someone who is released on unsecured judicial release or signature bond, those people are supervised by pretrial services. And so of specific interest to me is the 3rd page of that document, which shows that in 2020, we had almost 13,500 people on pretrial supervision. That's a program that is funded by the county. We have what amount to probation officers that keep track of folks that are released. These are felony cases. You can see there's a separate column for misdemeanors, but 13,500 felony cases that are on pretrial supervision. And we have a failure rate. We had a failure rate for that year of 2.5%. Now you might say, does that mean 2.5% of these people committed another crime? And the answer is no. Only 0.78%, so 78/100% got a bench warrant issued for them for not showing up for court. And another 1% failed because they had a warrant issued because they weren't complying with the requirements of pretrial release. And so out of 14,000 or 13,500, we had 2.5% that failed on pretrial release. And that means they went back into jail and they didn't get back out again. I say that to you because I want you to understand that when we release someone on pretrial supervision, we do it because we want them to be supervised in the community. And so we as a court have made a significant effort to make sure that that program continues to be funded. We asked for an increase in funding again for next year. And that is even though we know that the number of people who will be released with unsecured bonds is going down because of the Bail Reform Act that was passed. But yet, because of the large number of cases that we face, we know that there are going to be more and more people, raw numbers wise, that will be released on pretrial supervision. And so that aspect of supervision, that aspect of accountability is extremely important to us. The other thing I want you to know is that when it comes to serious violent felonies, so the 7 deadly sins that were talked about before, those folks can only receive a bond if they go before a Superior Court judge. Each time I preside as the presiding judge, I get usually a calendar of 8 to 10, almost all murders, some other serious violent felonies. And I can just tell you that in 16 years, I think I've released one person on bond for murder, and that was a consent bond with the district attorney's office. So that's what you can expect as far as what we see with serious violent felonies. There are other bonds that go before, or bond issues that go before magistrates. And as has been said, there's been some great progress in that regard. I'll tell you, I asked for the list and I got the list. And I'll tell you two things that I saw about it. One is that unfortunately, there were a number of cases on there where there wasn't a mistake made. They actually were released on unsecured judicial release for the ones they were permitted to, and on other cases, they were not. They had cash bonds. I don't know how those got on the list. I'm not here to pick at it. I'm just here to tell you that I took it seriously and I went through the list. There were some that were wrong, and I brought it to the attention of the judges who I saw on that list, magistrate judges who were on that list. And then there were some that were counted on that list, but yet what had happened was that inadvertently a bench warrant had been issued for a defendant who had been out on bond for some time. And it's because the notice was sent incorrectly, wasn't sent to the right address, whatever it might be. And that bench warrant was set aside and the bond had to be reinstated. When you reinstate a bond, you can't change it. You can't because of an inadvertence. So these are cases that originated before the statute went into effect and had to be conformed to that time. It couldn't be changed after the fact. Again, I'm not here to quibble. I just want you to know that we've taken that seriously and we've reviewed the list, and I will continue to do that as chief judge. There was a suggestion that was made that perhaps there are some things we want to ask for, and that's exactly right. The first thing I ask for is if there's things that you all can help us get better data for, because the reality is that there isn't a single judge on any bench in any of the 159 counties in Georgia who wants to make a bad decision about a bond. We want to make the best decision we can, and we need good information to do it. So when I sit down to review and I get a GCIC that's got one naked arrest on it, by that I mean an arrest that doesn't have a disposition, it's of no good to me. There are literally thousands of dispositions that have not been entered around the state, and the clerks are overwhelmed. They need help to get those things entered, and better information yields better results. So I ask you if there's something we can do, whether it's unifying the information systems, creating one single database, whatever it might be, so that that information can be quickly, effectively, and accurately uploaded to GCIC. That would be thing number one. The second is that the reality is that there will be people who will be released from jail, whether it's with a cash bond, whether it's on unsecured judicial release, whether they're supervised or not. My hope is that whoever is released, that there is a possibility that they will have to check in with someone regularly. I know the reality is that when the bail bondsman put up a cash bond for someone, that their interest is to get that person back to court. And that's crucial. But it's also an interest of society that they not reoffend while they're on, that they not hang around and do, that they have a job, that they don't take drugs, that they do other things that they're supposed to do. And so my request to you is to enhance the ability for us to supervise people who are on pretrial release, whether it's through a cash bond or not. Because when I showed you those numbers, those are people who oftentimes they had a warrant issued for them because they had a dirty drug screen. And so, whatever mechanism they get out, and I'm not here to advocate for one or the other, I just want the best we can do so that when people are released, that they don't reoffend. And then the last thing I'll ask for is whatever you all do, I ask that it be done based on evidence. I can tell you horror stories about things that I've seen as a judge and things that I've seen as a prosecutor, things that, and I wouldn't presuppose to tell you that we should make policy decisions based on some of those anecdotes. But by the same token, I do ask that whatever we do based on evidence. And that's why I brought you these numbers here to show you what we're doing in Fulton County. Is it perfect? No, it's not. But we are doing the best that we can, when we see people who reoffend, when we see people who don't abide by conditions, they get rearrested and go back to jail. And when we have folks that are arrested on serious violent felonies, they have a high bar to overcome to get a bond. Now, I take a step back and say, understand that the Constitution requires that someone have a bond unless one of four factors exists. They are a risk to reoffend. They are a risk to commit additional felonies if released on bond. They're a risk to influence witnesses. So if they're a risk to the community or otherwise, then, or a risk not to come back to court. So we have to find one of those things before we can deny someone a bond. If we can't find one of those things, we're required to let them out because that's a constitutional right. So I don't say that as a defense. I say that just to make sure that we all understand what the presumption in the law is. The constitutional presumption is that everyone is entitled to a bond. In Fulton County, there's been an issue about the 90-day indict or release requirement. And as chief judge, after the statewide judicial emergency ended for Georgia, I extended that stay on the 90-day indict or release for 3 months, which is the most that we could do under the law, so that we could process those serious violent felony cases and they wouldn't just default to getting a bond, because that's what would happen otherwise. So the good news is that most of those cases, and you'll hear from DA Willis when she testifies, most of those cases have been processed through the grand jury. But again, I'm not here to talk about what they're doing as far as processing cases. I'm only here to talk about our role as Superior Court judges, and especially dealing with the serious violent felonies. So I hope nothing I've said comes across as being defensive. I am not defensive. I'm here to answer your questions. I'm here to provide you with information and to, again, reassure you that my intention is to protect public safety first and foremost.
Okay, got a question. Number 22. Chairman Green.
Thank you, Mr. Chairman. Judge, thank you for coming today. I'd like to ask you why judges are putting such a dollar amount on signature bonds.
I can tell you that is a practice that has existed for at least 30 years. And I say for at least 30 years because I've been a lawyer for 30 years, and I've seen it on bonds in not just in Fulton County, but elsewhere ever since I became a lawyer. So that's not a great answer, but the 100-year rule is about the only answer that I have for you without being flippant.
May I ask another?
Please.
Well, does that sort of give the impression to the public and media that the person got an actual bond?
I think that's a fair criticism of that practice. I agree with you.
Thank you.
Any other questions or comments to the?
Yes, sir.
What number are you down there, Alan?
When they put on a dollar amount on a signature bond, when they are finally brought to the bar of justice for flight or they didn't show up.
Yes, sir.
If they put that dollar figure on there, would they not be then responsible to pay that amount?
Mr. Chairman, my only answer to you is that it would seem to make sense that they would, but that is not what has happened over the years.
Right, but it could happen.
I believe it could, yes, sir.
I post a signature bond and they put $25,000 down. I don't show up. When they capture me and then they bring me back in, then they could then process me for the arrearage of $25,000. Then by that time they've already captured me, and that'd be like you're like your own bondsman.
Understood.
That makes a lot of sense, but you should be doing that.
Yeah.
So I just want to say one thing about, and I know you all have heard from, certainly in the Senate, they've heard from our sheriff, and perhaps you all have too, and you'll hear it from District Attorney Willis. As was alluded to, we have a jail that is designed to hold 2,500 people, and it's got 3,100 people in it right now. The last time we had that many people in our jail, we had a federal monitor imposed on us that cost the county about $100 million. There is a proposal, a feasibility study underway to build one and perhaps two additional jails in Fulton County to the tune of $200 million apiece. And so I just tell you that because I want you to understand that we are not saying the jail's at 100% and everybody else gets to go free. We're going to continue to put people in jail and keep people there who pose a risk to society and make those choices as best we can under the law.
But isn't there a rich irony in knowing that the Fulton County Jail is full and the Atlanta jails are empty?
I understand your point, Mr. Chairman.
I mean, that's just unfathomable to me why that continues to happen. Any other comments, questions? Thank you for taking the time to come down here to this committee and giving of your valuable time.
Well, I appreciate you all hearing from me. Thank you very much.
One more.
Oh, sir. Yes, sir.
I would like to, for the sake of the committee, and certainly good to have the judge here. But if you don't think that for the members who haven't been here long enough, I want to identify Ms. Deborah Nesbitt back here. Longtime employee of the Office of the Courts. Amen. Took a sabbatical, went to the Association of County Commissioners until she realized her hair turned gray and she had to have it dyed. And now she's back with the Office of the Courts.
Well, I can tell you, Mr. Chairman, I'm glad to be working for Deborah again. I worked for her before. I'm glad to work.
As I was when she the other day, scared me to death.
All right. Representative Evans, you.
And I really don't want to be an advocate but you know, I work with the chief judge here for many, many years and a lot of different cases. And I've never really could say that I really had a favorable attitude about the judicial system in Fulton County. But several months ago, I found that I hadn't seen him for a pretty good while, that he'd risen to be the chief judge. And it reaffirms my belief that Fulton County is going to straighten some things up and do right. You've heard him here today. He's very knowledgeable. He's very low key and he makes great decisions. And he's been a long time friend and I appreciate him coming. He wrote me last night and told me he's coming. I was going to Zoom in until I found out he was coming today, but and I appreciate him for taking his time. He's always done that, taking time and really cares about the public welfare. So thank you, Judge.
Chairman Powell.
I would like to ask a question for advice from the judge. Believe it or not, a lot of us are contacted by inferior court judges, traffic judges, other levels of judges. And we've reached out to a lot of them, and a lot of these judges, they'll pick up the phone, they'll call me. I guess I've been around here older than dirt probably, and a lot of them know me, and I asked them about coming, and some of them said they'd like to come to talk about certain issues, since we're looking at the influence and the growth of crime. And then they tell me that they can't come. They've been advised that they can't come to testify. Would there be any reason that a lower court judge couldn't testify to a House committee meeting hearing?
Every time I've been invited, I've come. So that's all I can tell you. I believe that's appropriate for me to.
Superior court judges, I've always had a saying that the difference between God and a superior court judge in Georgia is God knows he ain't a Georgia superior court judge. But these lower courts, the lower courts, the ones that deal with traffic violations and a lot of this type of stuff, they have a lot of anxiety. But when we've asked them about coming, they say they've been told they can't come. Who could tell a lower court judge that they couldn't come and testify about issues that we're trying to find solutions to?
I don't know the answer to that. I've had conversations with folks from the Judicial Qualifications Commission, and I know that they've never indicated to me that a member of the judiciary cannot come and testify before the legislature on a matter that deals directly with the operation of the court. Now, of course, I'm not going to come and talk about cases or issues that might come before me. And you notice I demurred when we talked about the jail and other things like that. So, I mean, there are things that I should not talk to you about, but there are things that I shouldn't talk publicly about, but I'm not aware of anything that would require that.
Would the holdup be if the case was pending that he was going to discuss, if it was pending?
Certainly possible. Yes, sir. Certainly possible.
Thank you.
All right. Any other business? Anyone else out there? I know there's some other folks out there in the audience. Pete, you have anything you want to add to this?
No, sir. I've already testified for this committee. Thank you, sir.
And again, we're going to try our best to have another meeting on Monday. We held off on having this meeting because we wanted the DA to come and give testimony and hear from her. But we're going to try to do that on Monday. So just watch your email. No, sir. If there's no other business before this committee, we stand adjourned.